Want evalueer je modelle en jy sê hulle werk nie. En dan sit jy jou model op die tafel. Jy hoef nie die detail soos in wat die ouens hom al klaar kan toepas nie. Gaan kyk nou hoe ou ander PhD's dit aangebied het, maar 'n nuwe model. En jy moet hom genoeg beskryf sodat ander ouens hom kan repliseer. Maar want die ding van navorsing is jy doen navorsing en jy sê daarso is dit goed en die anders kan dit weer gaan doen. Sorry man.
Good morning.
Good morning.
I just want to check the presentation. How do I go about getting that up for you?
Sorry.
No, going to the webinar.
If you go to the valuation of the property, Stephen Divovitz, halfway through there's a SARS deck. When they bought the property, there's a transfer duty declaration certificate, which shows you that they paid transfer duty when they bought it.
They bought it.
Well, you just double check me, but it's on the valuation.
Okay.
Good morning. Morning, everyone. Can I just ask to please unmute, all your mics for now, because I see that there is some conversations that are going on at the back, which might not necessarily be part of our conversation, part of our webinar today.
Hi, Akona, this is Marius.
Yes, Prof.
Can you allow me to do a presentation? I see that only meeting organizers and presenters can share, so I have to share my screen, eh?
Okay. Okay, let me unlock that for you.
Please.
All right.
Now we got, and now we're going into retest. How much is it?
8 kilograms is 319.
It's cheap, 319. From there. It doesn't go off. Like, yeah. 5 kilograms you pay about 2. Yeah.
James, just hold on. I'll phone you back.
It's 319.
Yeah, that's what I'm saying. And check 5 kilograms.
It's 4 kilograms for 200 grams. We have 8.
One. Yeah, mine is about 8.
Okay.
Good morning, everyone.
Good morning. Good morning.
Good morning. My name is Likani Lebani. I'm from the DTI. First of all, I want to apologize. We are not able to share our videos, so you will not be able to see our faces for now. Our IT are trying to sort that out. So myself and Akona, we are the organizers. So unfortunately, those who have not met us before, you won't be able to see our faces. But nonetheless, I want to welcome everyone to our research forum on business rescue practitioners. We have 3 presenters today from University of Pretoria in the name of Professor Marius Pretorius, as well as 2 other presenters from Engaged Business Turnaround. But just as a brief background, our research forums are held on a quarterly basis, which means we have 4 research forums per year. The aim of the research forums is to share information in terms of what is happening in practice, but also to try to improve our legislation. So for today, we decided to choose the topic of business rescue practitioners. I think most of you will realize that business rescue is one of the key things that the Companies Act tries to achieve. But over the years, we have seen that the role of business rescue practitioners actually plays a key role. Some years back, we did a study on case studies just to try to understand what will be considered a successful business rescue process or rescue of a company, so to speak. One of the key issues that came from that study was that the role of the business rescue practitioner over and above their technical skills plays a very important role. For example, one of the case studies specifically highlighted that the ability to negotiate with the various key stakeholders was one of the key elements that either led to a successful rescue or failure thereof. So this is one of the topics or topical areas that we want to go further. Then more recently, we have also tried to look at the business rescue profession in terms of whether does it require more regulation in order to enhance the profession. But as you will know, more regulation does not necessarily mean a better business rescue practitioner will basically come into being. So today's topic is one of the areas that we think will shed light into what needs to be done to enhance the profession. So having said that, I want to introduce the key speakers for today. As previously indicated, the first speaker is from the University of Pretoria, Professor Marius Pretorius. Most of you, I think you have, you somehow know or have engaged with some of the work that Professor Marius Pretorius has written. He is a specialist in the area of strategy, leadership, and turnaround strategy. Then the other two presenters are from Engaged Business Turnaround, Mr. Ian Fleming and Mr. Peter Gordon. Turnaround, Engaged Business Turnaround has done quite a number of business rescue assignments in the area of mining, manufacturing, retail, financial services, and agriculture. So in summary, I will say, if you look at Engaged Business Turnaround, I will say they have skin in the game in terms of business rescue. So this is one company that we believe will help us from a practical perspective understand to say what makes a good business practitioner. Then Professor Marius Pretorius will be offering more of an independent academic view in terms of what will make a good business rescue practitioner. So without much ado, let me just go to the house rules. The first thing that we request is that if you are not on the podium, we request that you mute your mic and then you only unmute it when you have a chance to speak. So in terms of procedure, we'll invite Professor Marius Pretorius to give the first presentation for about 20 minutes, and then we have a question and answer session. Then thereafter, we have Engaged Business Turnaround to give their presentation, equally followed by another 30 or so minutes of questions and answers. So that said, may I welcome everyone to our research forum at the DTIC, and then invite Professor Marius Pretorius to take over. Over to you, Professor.
Thank you, Likani. I just want to check, can you hear me clearly?
Yes, we can, Prof.
Okay, and you can see what I have on the screen?
Yes.
All right, so I can start with a presentation. I just want to confirm, Akona said that I have 30 minutes. Is that correct?
Yes, that's fine. 20 to 30 minutes.
Yeah. Okay, guys, I have about 60 slides, so that means less than 30 seconds per slide, but some of the slides is a little bit repetitive, and it's confirming something else, and I want to just tell a straight story. Firstly, thank you very much for inviting me to this session. I do appreciate and the discussions that we had to get us here with the rescue practitioners that will follow. And without any further ado, I want to get into this process. I'll quickly went through the slides. As you see that it is being recorded, so the recording will be available. So the question is that of what we know. I just want to see whether I can move this. Okay. Okay, it seems like I have very little control over the slides as we go ahead, so I'll be very careful. I want to start off by then starting with what makes a good business rescue practitioner, and I'll try to be finished within about 25 minutes. We know that for rescue practitioners has become a sought-after profession, but there are many practice problems that has been identified in various research projects already in the DTI. And most of them are associated with abuse. So abuse is the opposite of professionalism. The Act doesn't really give us sufficient detail of how a business rescue practitioner must look or act. And there is no really accreditation framework. So the thing that we say is what makes a good rescue practitioner depends very much on who is asking. If you are an evaluator, then you look at it from one perspective. If you are a creditor, you would look at it from a different perspective. So the affected persons will all have different views. And to judge whether somebody is a good or a bad rescue practitioner, you require a clear understanding of competencies. So I'm going to spend some time on the competencies and then on how to evaluate each competency. So you will see in the end that we will refer to more or less 7 competencies, and then how it is judged for the different levels of people doing so. The focus is on the competencies, and the competencies that I'm talking about here is in order to save a business, not so much on the BRIL option. Okay, the BRIL option is very much associated with liquidation practices and the liquidation law and the things that goes around the insolvency. I'm focusing on what makes a good, you can almost say, turnaround professional, a person who will turn the business around or save the business so that it can proceed as a solvent entity and an operating entity that can still employ people. Okay, so I'm going to look at 5 elements here. The acumen, the tasks, the supra competencies, the competency levels, and then I'm going to give you a practical example of how it's been done in the industry. And on that, I will spend about 10 minutes. So what are the key competency insights that we are talking about? Just want to see whether I can move this ribbon a bit. So what are the key competency insights? So the first thing we must understand is what is the process? And it's basically a linear process that we are talking about. You will see that there's a filing, an appointment of the rescue practitioner, creditors meeting, an employee meeting, and then there's a period of time that elapses until the second creditors meeting where the vote takes place. And then there must be reports to the CIPC until such a time that there is a substantial implementation. So the tasks of the rescue practitioner is one of, firstly, to take management control, including probably financial control, the bottom one there. And you will see that there are specific tasks that is part of this main task. So subtasks and main tasks, that's got to happen. The second task is to investigate the affairs of the venture that is in distress. Okay, that will include a viability analysis. So you will see a feasibility analysis will link into a viability analysis into the next step, which is once the plan is compiled, you will see here that that is to a point in time where the second creditors meeting takes place. So all I'm trying to do is give you an idea of all the tasks. Once there was a vote on the plan and it can now be implemented, then the rescue practitioner must take responsibility for implementing it. And this must all happen within what we call the supreme tasks. that the rescue practitioner must act within the law. Okay, so that is quite important. You must follow the statutory principles of the Act and do things according to what is the way proposed in the Act. Okay, so then we must understand also thinking of people, and I'm going to run past this slide to a concept which I want to put forward to you, that if we want to look at a rescue practitioners are involved in what we call the concept is acumen. Okay, and you can see there we have the ladder concept. From the bottom up here, a novice is only somebody that heard about business rescue. They don't know anything about rescue. If they become proficient, they can interpret the Act and apply what is standing in the Act. But we are looking for people that are experts, okay, and they can master. And those are the people that have the concept of acumen. And I'm going to give you some examples of acumen. Barring this little picture over here that explains it a little bit, we say that acumen, that a good rescue practitioner has acumen. Then their knowledge and what they know is, it's not, you cannot put your finger on it. It's sticky, it stays with them. They can tell you about it, but it stays with them. It's sometimes very tricky. And it's also leaky. They give it out, but other people cannot really take it. Okay? It's often hidden aspects of understanding of how a business operates. So you can see we're climbing up a ladder. Another way of looking at the same thing is what we call the Acumen Calculation, or the wall concept. We start off with people who are ignorant at the bottom. They don't know that they don't know. We have rescue practitioners like that have been licensed. I can tell you about them because people complain about them to me often. But they mostly have what we call explicit knowledge. And you can see here is that it is a formula that we calculate and say you have to look at the explicit knowledge of a rescue practitioner. The second thing is the motivation of that rescue practitioner. Why is he a business rescue practitioner? Is he only there to make money? Is he actually a liquidator that is looking for something else to do? What is the motive behind doing it? And then we also have other elements in the process, the focused experience. How experienced is the person? And can they apply their experience in alternative circumstances? But what is important about this formula is, and I don't want, the idea is not to flabbergast you with this formula. All you have to understand is that in this formula, there's a multiplication, a multiplication, and a multiplication. So what we say is that any one of those things are zero, then you multiply by zero, and then everything becomes zero. Okay? So you have to understand that it's a multiplicative calculation that we are looking for. Remember, you want to judge good versus bad rescue practitioner. And one of those things, if it's absent, can make it a bad rescue practitioner, while he might show many of the other things that might be available in the formula. So what we are saying is that you must look for the guy standing there. If you don't see him, and that is typically the situation that we are facing with the good and the bad rescue practitioner. Do you see what you are supposed to see? And the thing is about acumen is that it cannot be transferred easily. Those rescue practitioners, which are the senior guys in the industry, they know stuff which they cannot really transfer to you. They walk into a business and they just know for various reasons. They have tacit knowledge. It's not, you are not able to put your finger on it. And we find it very difficult as the educators to get those components so that we can educate people to be rescue practitioners. Okay. So what are the core competencies then that we are looking for in a business? And I'll come back and I'll give you some examples of the acumen again. I have a very nice little story which explains it. So, but first I want to look at the core competencies that we are investigating for this. What must you judge? so that you can judge the business rescue practitioner as a good or a bad rescue practitioner. And it's a lot is to do about acumen, and which we have already described. Okay. So let's just look at the two words here. And I'm sorry to bother you with this, but if you don't understand this, then you cannot make this judgment. It's very important. What is a competency? And I have a better slide. Remember, competencies are complex. They involve knowledge, skills, abilities, characteristics. And some of the skills are very difficult skills like problem solving, analytical thinking, leadership, mindsets, patterns, motives, beliefs, values. How do you as an outsider come and judge that? Okay. They are associated with individuals, but they can also be associated with companies. So in this process, we want to look at what must a business rescue practitioner demonstrate to us in order to become a higher level business rescue practitioner. So that's the idea behind this whole thing. Okay. So this slide is quite important that I want you to understand that we are looking at what must the rescue practitioner do, what must we evaluate in order to say this is a good or a bad rescue practitioner, and then how good is it, the level of mastery. Think about a child learning to ride a bicycle. What must the child be able to do? There are several things. He must be able to pedal, to balance, to move forward. Those are the whats. How good is the guy doing that? Okay, when they start out, they fall, but eventually when they are at a high level of competence, then they can jump over rocks, they can jump on the pavement, they can even make a somersault sometimes if they're very good. So it's the level of competence. So competency, what? Competence is how well are they doing it. And those are the levels that we would find in the literature that people describe competences are. We have the novices, the competent, the proficient, the expert. When I drew this slide about 3 years ago, I wasn't sure that we have any masters business rescue practitioners in this country yet, but that might have been changed, or it might have changed. For me, it's very difficult for me to make that judgment, and you will see why I'm saying that. So we are in a little bit of a bind. Think about there on the left-hand side, here where you have the activities. Those is what the research have shown us that rescue practitioners must do, the activities or the practices that they execute. And they get together in different tasks. And you can see there, the tasks are associated there with the colors. They must take control, investigate affairs, and I'll give you another picture of the same stuff where it makes a little bit more sense. But what is important is that those things are also very much intermixed. And the rescue practitioner must have certain competencies. Okay? They must be able to make sense, collaborate, take decisions, which eventually bring them to the navigation function. And there's another slide. Let's quickly run through those 4 competencies there. A sense making. Here's a person that must go into a new business, which is in distress, and go and make sense of what is given to that person. It involves a number of things, but look at that ability to make rapid and accurate judgments without detailed analysis. So they must have some experiences that they can lean on. Even if it's not their own experiences, it might be the experiences of team members or a second rescue practitioner that works on the team with them. They must be able to collaborate, find trust, involve other people, all the stakeholders, all the affected persons. And that often happens in a hostile process. There's also the concept of decision making. They must be able to take decisions. They cannot just let it go. We see many of these rescues take years because the rescue practitioner cannot get to a decision. It's one of the big problems that we are reported in the industry at the moment. And then finally, the integration. You are required as a rescue practitioner, if you're good, to put things together. After analyzing it, you must synthesize and put them together, again in a different format, so that there can be a business that is working. So if we put us in the same picture, those are the tasks of the rescue practitioner, but the rescue practitioner must be able to make sense, to collaborate, make decisions, and integrate all the information available so that they can make proper decisions. There's the same picture of the same elements there, just those 4 core higher order competencies. And remember, the aim of the rescue practitioner is to navigate a crossover from a current distressed position to a new best position. And that involves a number of things, and there are articles that I will make available to you if you are interested in that afterwards, to read those details of those, but I don't want to lock you into that now. So typically this picture only shows that we are saying that there are levels of competence. How competent is a person? Is he a novice, a competent, or proficient, or an expert, or a master? And they all show different signs of various types of things. As I've already said, I'm not sure that we have masters. So when we did this development, we stopped at the expert and we moved the novice. So we are only working with those 3 in the business rescue industry: competent, proficient, and expert, typically associated with junior, experienced, and senior rescue practitioners. And there are much more detail in these slides, which I'm not going to bother you with now because I'm limited to a certain amount of time. And I want to get to the competency measurement, or a measurement of a competence. How do we determine how and at what level? Okay, so what I'm going to share with you is an example of one professional body that I'm involved with. The one that I can report on is this one. How do they go about evaluating the good or the bad rescue practitioners? And you have seen in the news about rescue practitioners that's been licenses been taken away and so forth and so forth. So how do they go about this? And in the TMA, what they normally do is, remember, we do a workshop where people apply in order to become licensed in the TMA. And what we do is we put together a panel of professionals. So there are at least 3 people on the panel, and I am the chairman, which is independent. And I will just run the procedures, and those 3 professionals will evaluate another professional. So it's a professional judging a professional. Sorry for that, just go in the right direction. I'm leaving up this slide a little bit for you. Maybe you want to look at it afterwards, but it tells about people judging other people. If you want to say good practitioner, bad practitioner, you must know something about being a practitioner. And this is important. For example, it says, only a good musician can judge music. An ignorant person cannot judge it. So I cannot judge whether you're a good musician, because I know nothing about music. If I sing in church, they chase me out of the church. So is that bad? It is. If you are a grammarian, then you can judge grammar. I cannot do that because it's not my speciality. So we must look at the different things that can you judge. And sometimes the judging is very difficult. So what we do in this case is we are asking professionals to judge other professionals. So it's a very dangerous process. I continuously warn the panel members, and they must also even complete a statement about their own ethical, professional, and reputational status in the industry, which is peer-based. What are your peers saying about you? Do you have any reputational issues? Are there any clashes? Do you have a case against you? And all of those things must be declared before they can be a panel member to judge whether somebody else is a good or a bad practitioner. So we use 3 levels of competency: weak, medium, and strong. And I have another slide which contains this as well. And I just want to share with you the concept of acumen. What is it that we are judging a person by? Here's a little story, 3 slides. A giant ship engine failed. The ship owners tried one expert after the other, but none of them could figure out how to fix the engine. Then they brought in an old man who had been fixing ships since he was young. He carried a large bag of tools with him, and when he arrived, he immediately went to the work. He inspected the engine very carefully, top to bottom. 2 of the ship's owners were there watching this man, hoping that he could find. And now I can't see because there are now some stuff on top of my on my slide which I cannot remove, unfortunately. So please read that last paragraph there. The old man reached into his bag and he took out a small hammer, and he walked and he tapped on the walls, and instantly the engine lurched into life. A week later, the owners received a bill from the old man for 50,000 rand. What? The old man exclaimed. He hardly did anything. So they wrote the old man a note saying, please send us an itemized bill. And all we saw you was tap with a hammer. So the guy sent a bill. He said tapping with a hammer was 5 rand. Knowing where to tap was 49,995 rand. Okay, so the concept that we are saying here is the good rescue practitioner is the one that knows where to tap. Everybody doesn't know where to tap. You might have a hammer and you might walk around, but if you don't know where to tap, you are not the good rescue practitioner. And remember, in this case, we are kind of referring to the rescue practitioner as the senior, the more senior the rescue practitioner and more professional level that we are talking about. So in this process, the panel will judge the rescue applicant, for the rescue practitioner, the applicant, on 7 competencies. And I think this is more what you were interested in originally when you invited me to come here. And I'm going to share with you again. We judge them at 3 levels of competence: weak, medium, strong. And you can see at the bottom here that the slide has six levels. So you can get a 1, 2, 3, 4, 5, or 6 being judged by your peers. So the first thing that we judge a rescue practitioner on is the ability to assess the stress and to contextualize the specific particularity of the problem of that business. They are not all the same. Every business is a unique, particular business. And the cause of the distress is not the same. Where does it originate? How severe it is? What are the resources situation? So we are judging this person, the applicant, on his or her ability to make a distress assessment and contextualize the distress. Okay. So we will look at stories and ask them questions on specific cases that they have been involved in before. The second one is the maturity of judgment and reasoning. Is this person knowing what he is knowing? Do they have the knowledge, or don't they know that they don't know? Have they heard of things, or do they know things? Can they identify the causality? Or are they just giving you a superficial, oh, the business is in distress because they have cash flow problems? That is always a sign for me that people don't know anything about business rescue if they say that the reason for business rescue is cash flow. Okay, so that could be a heuristic that I apply. Origin. So we are looking at the maturity of judgments. So we will give, in that interview, I will give the applicant, for example, a case, and I'll say, how will you judge that case? And then the panel would ask questions around that in order to see the maturity of judgment. So please, we say, first one, we said to us, can they make a distress assessment? Second one, what's the maturity of judgment? The third one is how would they respond to the distress? So that means what strategies will you come forward with to address this specific type of distress that we have discussed so far? Okay, so the distress response. Then the fourth one is financial. Now we turn into the financial. The first one was about business. Now we're turning into the financial component. What recognition mechanisms do they have? What do they tell you that they monitor? Can they do a financial distress assessment? And it indicates to the application of ratios and alternative indicators. What do they use in order to do something like that? And then the implication of the financial status. If that is the case, then what is the implication? How do they judge that? And again, we ask stories and so on, how to judge people, what makes a good rescue practitioner. The sixth one is legal contextualization. I just want to see, I have a couple of minutes left. Can they put it within the law? Recognition of the legal context and specifics, opinion and response about specific issues, pre-judgments that's happened in the industry. What is the case law that will support them? And that will give us an idea about the law understanding of the applicant. And then the last one, which is a crucial one, and it's an overrider, is the ethical professionalism. Here we have people evaluate themselves. Can they recognize the issues? What are the judgments of the issues and the challenges? And we will talk about certain cases. And we do it on both sides. The panel must undergo this, as well as the applicant. And they fill in what we call a declaration of conscience. Can they openly sit in this meeting and participate? And are they allowed to judge other people, or do they have issues with themselves in the industry? And that is both for the panel and for the applicant. Are they willing to be scrutinized publicly? So the things that we look at there is recognition of issues, judgment thereof, solutions, maturity. Reputation under peers is quite an important one. So just look at this concept of professionalism. There are people in the industry that say, we are not talking about the business rescue industry. We are talking about the business rescue profession. Okay, you must be a professional to be a player in this industry. It refers to look at those issues, conduct, behavior, standards that work, the work of professionals. Habits of the mind, reputation, ethics. Those are the issues that are associated with professional. You cannot have an abuser doing this. Okay. And you ask, depends on who you ask, you will hear people talk about those abuser rescue practitioners, which culminates in the 3 levels: weak, medium, strong, 1, 2, 3, 4, 5, 6. And each of those 7 things are then rated. What we then do is the 3 people will rate them individually, and they will give me those. They don't know the one that said to the other one, what is that level, that level. They rate individually. I take those separately. I work out the average score. I see what are the deviations for that, so that we can say, here is what's happening. So in the process, we say, people fill in those forms. You must be conscious, a declaration of conscience form. Then we look at the people on their CVs to judge their explicit knowledge and their acumen and their experience and so on. And then only we judge them like there in Form 2 in the process of on those competencies, or if they are competent or not. Everyone will then also in the panel will fill in that this person is judged as a junior or associate turnaround professional, a certified, or a professional. It's associated with junior experience, and the reason for that is given on that form. Then after the interview, they repeat this exercise, separated from what they did in the past. They do it again after the interview, and they'll give the reasons for this choice. Then there are some development proposals to improve the work of the rescue practitioner. And TMA is unfortunately the only professional body, as far as I know at this point in time, that does a process like that for each applicant. And it's quite an expensive process to get all the panel members, to get them together, to do this evaluation. It takes a lot of time. And my proposal is, or suggestion is, that all other professional bodies can suggest or investigate the application of a similar process. They don't have to use the same process. They might think of other things as important, but that there is a process that we can evaluate people from day one to be good practitioners and move up in the profession rather than just in the job. And I think that's where I will probably end. If there are questions, then I will do my best in order to answer them.
Thank you very much, Prof, for a very insightful presentation. You had 5 more minutes, but it's still fine. I will then now give an opportunity and open the floor for questions, for comments, and also for any discussions. So we have about plus minus 20 minutes or 15 minutes to be able to do that. So I think the way I would want us to do it is maybe to take 3 to 4 questions at a time, and then Prof, you can respond to those ones, and then we go to the second set of questions. So the floor is open.
It is useful if people put their questions also in the chat box.
Okay.
That's also helpful for me to follow. So if you have a short question that you put in the chat box, we can monitor that.
All right. I've noted a hand from Saka SG. So please go for it, sir.
Thank you very much. My name is Mpho Moikangwa. I am the Secretary General of the South African Cabin Crew Association. Mine is more or less of a statement based on the presentation that has been made, to say that in the aviation industry, if I may declare, let's say within a company like South African Airways, you find that there is an abuser from the BRP, and you find the involvement of the DPEP giving instructions to the BRP, and more than anything, then they then become negotiators, and they don't even come with the skills that are needed in the aviation industry. So what I would like to say, I concur with Professor. And lastly, it is to say that it's very difficult in terms of the judgment. Once the business rescues are there, you then look at the intention and the amounts that have been paid, they've been paying themselves. So I think the regulation in terms of that, it needs to be looked at, and how companies cannot be scammed by the business rescue practitioners. And then lastly, I would also like to request for the presentation to be emailed to us so that we can even learn more about it. Thank you for your time.
Thank you very much, Paul. And I think that was more rather of a comment and also maybe agreeing to certain things that came through the presentation. Prof, with your permission, of course, would you please be kind to maybe give us the presentation too, so that we can be able to, circulate it to our participants?
Yeah, I can do that. It's not a problem.
There's another question, another hand from Stefan Ho. Can you please go for it, Stefan?
Yes. Can you just confirm that you can hear me?
Yes, you are very audible.
Thank you. Prof, I'm a business rescue practitioner, and I've noted that particularly some of the larger accounting firms, when certain individuals from the firms are appointed as business rescue practitioners, we all know that there are statutory rates, hourly rates, which one can charge for a large company over a certain number of points. It's 2,000 Rand an hour, including VAT. Comes down to 1,500 an hour, including VAT for medium-sized companies, and 1,250 Rand an hour, including VAT, for small companies. Now, if a business rescue practitioner feels that he should earn more than that, he's required to convene meetings of affected parties, basically shareholders and creditors, and get their approval to put in place a remuneration agreement. Now, assuming there is no remuneration agreement, what I find is that a practitioner gets appointed from a large firm in a big matter at 2,000 Rand an hour, then proceeds to employ 5 or 6 or 7 people from within the practice, and often charges them out at 4,000 Rand an hour, for example, just to assist him in conducting the business rescue. And that seems strange and seems to undermine the regulation, the statutory provisions, which limit the hourly rate of the practitioner himself. So he basically employs people who are junior to him at greater rates. And I just wanted your feeling on whether you consider that not to be in the spirit of the legislation. Thank you.
Yeah, Stefan, I must be very careful here, but I agree with you. I see a lot of abuse. We have done research into the costs of business rescue and the ways and the means that some rescue practitioners access money out of the business. Access money out of the business is sometimes scary. Like they will sell an asset and they will take commission on the asset. They have all kinds of ways. You are referring to one of those. And unfortunately, again, in applying my own heuristics to a business rescue practitioner, if he appoints 3 other people to do his work, then I'm wondering about the competence of that person, unless it's a massive sized business. I've also worked in teams on these different of such a business, and sometimes it's required that there's a team. But there's massive abuse about money making out of a business in distress already. I'm not sure how businesses, and most of them cannot afford it anyway. I hope it answers your question to some extent.
Yes, we thank you. We know that there definitely are abuses, and my only point is that something seems wrong in a practitioner who's not allowed to charge more than a certain rate per hour, being able to employ people from within his own firm to assist him at greater rates. It doesn't make sense to me.
Yeah, but I mean, there's a lot of disagreement about those rates. Most people will say those rates came in 2008 and they haven't been adjusted. They're not in line anymore. And those are all ways that people apply to get around the problem of that argument.
Yes, that is true. Thank you. It's a difficult one, but unfortunately, we are bound by the law and whatever the prevailing law is at the time. And if there's something we don't like, we're supposed to put our hands up and get it changed. And if it's a reasonable request, it's meant to then be changed. And I understand, for example, the insolvency tariff is a minimum fee for a trustee in insolvent estate of 2,500 Rand in total. Now, how on earth can somebody be expected to take an appointment, be there for a number of years, have to attend to all sorts of, have to discharge all sorts of statutory duties, and yet have to be paid 2,500 Rand because there are no assets, and still share that 2,500 Rand with somebody else who's appointed with them? So I understand it's crazy, but nevertheless, we are bound by the law, and you can't start looking at novel ways of getting around it, unfortunately. That's my take.
Prof, if there is no other comment from you, thank you so much, Stefan, for that as well. I think it's very important, and also that some of these things come out, because also from our side we are taking some of these comments, and then so that we will be able to see in terms of from the regulation point of view what is it that can be done. But maybe before I move on, I see there's a hand from Mpo from Saka. I'm not sure if it's the old hand or is the new hand. Can I just check with you maybe before we proceed to the next set of questions?
Yeah, hi, Akano. It's Feroz Kader. I'm also from the Saka Union, the public relations and the negotiator. There's three questions that I need to ask the Prof. I think as the layman, we were invited into this, more especially that our organization, South African Airways, we represent the ground and cabin entities there. The first question I wanted to ask, and it relates to the qualification in terms of sectors. Does business rescue practitioners need to be specially qualified in a particular field to excel in that field? And I saw your presentation at the beginning, and your presentation didn't say that. However, I just wanted to find out, do you need a particular qualification in terms of business rescue to go into the aviation industry or the maritime industry, etc., to save them? Is that something you need? That's question one. Question two is, the speaker before me made a very valid point that irrespective of the laws and how the laws are crooked in terms of I must earn 2,000 Rand as a business rescue practitioner, yet my colleagues who are, and most of them would be, least qualified or least experienced, will then qualify from the same company for 4,000, 5,000, 6,000 Rand an hour. Now, that is the biggest, I think it's the biggest con that we're all been going through in recent times, especially in the last, call it the last year. The third question is there a panel of business rescue practitioners that gets reported to a group, and that group goes to a hearing, etc., when they do things wrong? Because from our experience, and we had very good experience into the business rescue, our business rescue went on for 15 months, and they were clueless to what they were doing. But nobody held them responsible because they said they were appointed by the courts. Who reprimands and who can withdraw the application or remove them from a particular process? I hope you covered and understood my question, Prof. I'm sorry to do this. Thank you.
Okay, so I'm going to try and answer your questions. And I think you might not like to hear what I'm going to say. Okay, so firstly, I'm saying you are related to the union and the SAA case. And I understand your position, and in my past as a rescue practitioner, not a rescue practitioner, as a turnaround professional many moons ago, I also had to let people go out of a business. Remember, your question about particular experience of the industry is very important. I can remember 5, 6 years ago, I spoke by accident to the rescue practitioner which you are referring to. And I said to them, would you be interested in looking at this business and this business? And he said, no, that's not my industry. I cannot focus on that. I don't know enough to work on that. That's always a good sign for a good rescue practitioner, that they will say, no, I'm not in mining. I'm not in this, I'm not in that. And especially something like SAA, which is very specific, makes it very difficult, although there are principles. At the same time, I must say, I remember this was a death wish appointment. If you took it, you're going to be dead. Your reputation is going to be screwed up forever and ever. Amen. So you have to ask 15 million so that you can pay your retrenchment package, because nobody else is going to appoint you in another rescue after this one. And it is not the fault of the rescue practitioner. SAA was dead. You cannot survive or make a dead horse alive. It was dead. It wasn't supposed to be in rescue. It had to go into liquidation. But there were so many other factors. The shareholder anxiety syndrome came through big time. So yes, money making is there. Yes, you have to have this. It is useful to have the experience of the specific industry. Now the next question is there a panel? We see that, for example, in the engineering industry, of which we copied some of the principles. If some engineer designs a building and it collapses, then it comes before a panel. We have panels I know that there is a panel in the TMA, but I cannot speak for the other 12 professional bodies that give licenses or support licenses to the CIPC. There are too many of those professional bodies, I think, whose members can apply for a license. So yes, there's a panel. Yes, it has functioned in the TMA. It costed lots of money because it eventually ends up in the court. So wrongdoing is recognized. They're trying to address it, but I'm not sure whether it's really working all the time. I hope that I've answered your question to some extent, and we can have this discussion about the dead horse suggestion, maybe to extend that in a different point of view.
Thank you, sir.
Bukani?
Thank you, Prof. There are questions from the chat, so maybe can you quickly address those as well?
Invariably, the BRPs tend to retrench as a way to ease a company's financial distress. Do you think this is a symptom of not knowing where to tap? Now, I can tell you that if I have to answer that question, Selo, I would say to you, what we would normally do, you go into a business rescue situation, turnaround situation, and you look at the big 5 costs. And if you don't focus on the big 5 costs, you will never fix the business. It's a rule of business distress response. If you don't fix the big 5, you will not be able to fix the business. And number 1 or number 2 is always employee costs. Now, there's a different way to look at it. I would always look at the management portion of the cost rather than the worker costs, because those are distorted. But you cannot fix a business most of the time if you do not fix the expenses. And the biggest or the second biggest expense is always employee costs, labor. And that's unfortunately the nature of the beast. Okay. The second one there that I just want to see is Buyani. As we all know that the posture of business rescue is aimed at activism for affected parties. The BR practitioner cannot be approved inclusive of salaries. The plan cannot be approved inclusive of salaries. Okay, you make a statement. I agree with you. But again, I'm saying, remember, you cannot fix a business by just putting in new money. You must fix the business. It's rule number 1. No operations, no business, not fixable. If you have been in business for 15 months and you haven't flown anything, you haven't operated your business, there's no business, it cannot be saved. Secondly, you cannot save a business by putting in new money. It doesn't work that way. But now I'm on the area of the next speakers already. Any other questions that maybe I've missed something here?
Prof, there's another question, Prof, from Muhadi. The one
Yes.
on self-regulation, yes.
Yes, go.
It says, can I read it, Prof? Would you favor self-regulation of the profession or strengthen regulation through the Companies Act?
Okay, let me just see. What is that question?
It's MM, just below Celo's question.
Okay, just repeat the question for me.
Would you favor self-regulation of the profession or strengthen regulation through the Companies Act?
Very interesting question. I'm not sure that self-regulation is going to work. I think that there's a requirement for the professional bodies to have stricter regulation, but at this point in time, I'm not sure how to answer that question, Meneer. It's not a straightforward answer to that question, the self-regulation one. I'll have to pay attention and think about it and maybe discuss a little bit to get a better idea of how it could be self-regulated, or could there be self-regulation elements that we could put into that. Vuyani, I was responding to practitioners appointing juniors earning more salaries than, oh, okay, yeah. Okay.
Nakani.
Yes.
Okay, can I go?
Yes, maybe we're going to take the last question for you, Prof, from Vuyani,
yes.
And we'll close the session now. We go to the next speaker.
Okay,
yes,
thanks.
please.
Thanks. It's not a question. I'm trying to respond to this question of self-regulation or strengthening the regulations through the Companies Act. I think the most challenge that the companies that are in distress are facing is that after having appointed the practitioner, they find it difficult to deal with that practitioner, precisely because the company is under distress. And for a company to deal with that practitioner in terms of removing the practitioner, they have to go to court. So it's if we are to address some of these issues, probably we need to look in terms of the regulations and the Companies Act, trying to make it cheaper for the companies to address issues when they have issues with the practitioners. Whether we use the companies tribunal or whatever, a tribunal, that at least the cost will not be exorbitant as they are when you are to go to the High Court. So self-regulation, I don't see it working, but if we try and address the issues in the Companies Act and the regulations, so that at least it is cheaper to navigate and manage the business rescue. Thanks.
Yes, I can agree with that. Like the removal of a rescue practitioner is not easy and it's expensive. But there's also sense in that, because what we would find is after the appointment, on the day of the appointment, the directors and the rescue practitioners greet each other, they shake hands, they smile at each other. But the next day, when the directors find out that they have signed away all their powers, they have no decision-making powers anymore, then they change. And let me just do this. They change like that. And they start attacking the rescue practitioner. They distrust him. They will send out messages. The directors are vicious on that second day when they realize that they have lost all their decision-making powers. And then if the rescue practitioner act correctly, but it's not the way that the directors wanted it to happen, then they will blame the rescue practitioners. The rescue practitioners are not always wrong. There are many times that they are wrong, and they can be wrong, it is true, but as many times they are doing the right things, especially if you go and look for those who are professionally and ethically doing this job for the right reasons. Okay, so I'm not sure, again, I like what you said, self-regulation is not so easy to work, and within the Act as it is at the moment, I'm not sure that, but it needs to be explored. And Lekani, I think that maybe it's now time for you to move over to the next presentation.
Well, thank you very much, Prof. And for any questions or issues related to the presentation, I've seen that you've shared your email there on the screen. Now, without wasting any time, I'll move to our next presenters from Engage Business Turnaround. And it's going to be a co-presentation between Mr. Ian Fleming and Mr. Peter Gordon. The floor is over to you, gentlemen.
Thank you very much, Lekani. Thank you to you and to Akona for the opportunity to present in this webinar. And thanks, Prof Marius, for an excellent presentation, and to all the questions. There were some very good questions coming through there. Prof Marius, I did his Certified Rescue Analyst program with the Enterprises University of Pretoria in 2016, so it was almost 5 years ago. That's before I was even registered as a business rescue practitioner. So yes, and most of our team, you know, we've at Engage, we now have a team of approximately 20 individuals, most of which are senior, and most of our team have actually been through his course. So one of the topics of this presentation is what makes a good business rescue practitioner. So I would certainly say to do Professor Marius Pretorius's course is a good step towards becoming a good business rescue practitioner. Now I'm only joking, although it is true, but we're not here to promote our colleagues in the profession. But yes, Marius certainly forms a fundamental cornerstone of the business rescue profession. So let's talk about what makes a good business rescue practitioner. You know, multidisciplinary teams, we believe, is one of the cornerstones. And you know, Marius talked about 7 of the sort of core skills that are required, core competencies, as he refers to it. We think it's absolutely critical to work in multidisciplinary teams. It's easier for us now, having built up a large team of the various disciplines. I'm aware that a lot of business rescue practitioners do work by themselves, but it's very important for those business rescue practitioners to have all the required skills at their fingertips in order to do business rescue, restructuring, and turnaround properly. You know, I often rattle off the skills that I believe are critical in order to do it properly, and I've written them down in front of me, but I can recite them off by heart. Leadership skills, entrepreneurial skills, strategic skills, operational, financial, legal, corporate finance, psychology, communication, and negotiation, as Lekani mentioned earlier, are all absolutely critical skills. And as a good business rescue practitioner, you don't have to be an expert in all of those things, but it's very important to have a good general knowledge as to when each of those skills needs to be applied to a specific situation. You know, you'll find some business rescues where, you know, operational skills are absolutely critical, and operational and financial skills, for example, and other skills are less important in that matter. So you get some very legalistic business rescues where there's a lot of litigation, and then obviously the legal skills become important. One of the things Marius, I remember him saying when I did the course with him in 2016, 2017, is that it's almost impossible for any one person, any one business rescue practitioner to possess all those skills. But it is absolutely critical to have those skills at one's fingertips. So now as a multidisciplinary team, we have all those skills at their fingertips, and we believe a good business rescue practitioner has to have those skills at their fingertips and be able to mobilize those skills fast. Mobilizing skills fast is absolutely critical, and getting things done quickly is absolutely critical in the business rescue environment. Because remember, the company's running out of money. They're in business rescue because they don't have cash. And the longer you drag out a business rescue, the quicker that company runs out of money. So being able to get things done quickly, on the spur of the moment, make decisions quickly, as Marius spoke about as well, is absolutely critical. Also, the advantages of having a strong team is depth. You know, we often talk about if one business, we normally take joint business rescue appointments, and I think a lot of business rescue practitioners do that as well. We often talk about if one business rescue practitioner gets hit by a bus, then at least there's another business rescue practitioner and all the skills behind him, you know, to be able to carry on from where he left off without severely negatively impacting that business rescue. You know, it's also The work that we do is very stressful and very fast-paced, and it can lead to burnout very quickly. So we often say it's very important for members of our team to take leave, to get out the office, to go on holiday, to reset, to regroup, and then come back fresh, fresh and creative and strategic. And that's also absolutely critical. The time that we spend out of the office sort of rebooting is almost as important as the time that we spend in the at clients in the office doing the work that we do. Obviously, I've rattled off all the skills that Marius and I've both touched on. Ethics is most certainly one of the most important overriders. Everything has to be done, with ethics in mind, and that leads to my next point: is never to give anyone a reason not to trust you as a business rescue practitioner. Relationships of trust with affected parties are absolutely critical in order to get things done fast and get them done effectively. We're busy with an extremely complicated matter at the moment. It's a fairly large equipment hire company, and without the trust of all the key parties, it would be impossible for us to have achieved already what we've achieved in the month or so that we've been involved. One of the big problems with business rescue and business rescue practitioners, and a lot of business rescue practitioners, they do not enjoy the trust, of the major creditors, and affected persons, which makes it almost impossible, for them to do their job, and result in a lot of business rescue failures. And often those matters will just end up in prolonged litigation, and that's not where one wants to be. Let me just, I think what we'll do and how we'll do this is, I'll go through what I believe is, makes a good business rescue practitioner. Then my colleague and business partner, Peter Gordon, will do the same. And then I think we can move over to some practical examples where we can speak about business rescues that we've been involved in, and the outcomes and so on. Another very key aspect is the ability to work with management. And to work with creditors and other affected parties at the same time, for example, employee representative groups. It's so critical to work in the balanced best interests of all affected parties in order to benefit the company at the end of the day, and to get the company out of trouble, on the other side. One of the most important things we believe in is publishing the business rescue plan within the 25 days that are prescribed by the Companies Act. It's become almost the norm for business rescue practitioners to ask for an extension as far as the publication of the business rescue plan goes, but we always try to do it within 25 days because that wins the confidence of the creditors and all affected persons right from the outset. The moment you start delaying the publication of a plan, you start losing the confidence of creditors. You require the confidence of creditors and other affected persons right from the outset in order for a business rescue to be successful. The business rescue plan does not have to be ultra specific. If there are unresolved issues by the time that the business rescue plan is published, then the plan can be published without those issues specifically having been resolved. The business rescue practitioner can leave himself the latitude and the flexibility to be able to resolve those issues after the plan has been published and voted on. We're not expected to perform miracles. Very often there are matters which cannot be resolved in 25 days before the business rescue plan is published, and those simply have to be resolved after the plan is published and voted on. And provided you have the trust of the creditors, they generally are reasonable parties and reasonable people, and they will understand that there's a lot of things that need to be resolved after the publication date. Having a business rescue plan approved is not the end or even near the end of a business rescue. Implementation of the plan is absolutely everything. Putting a plan together is the easy part. Implementing it is the difficult part. Unfortunately, a lot of business rescue practitioners believe that 90% of their work is done by the time a business rescue plan is approved and adopted by creditors. But that is most certainly not the case. Peter, over to you.
Ian, thanks. Yes, look, I think between you and Prof, you've certainly covered the major points. I think a highlight for me is what you've both touched on, and that's this issue of ethics and trust. To me, those are the foundation. They're the cornerstones of successful practitioners and successful rescues. If a rescue practitioner is not trusted, and let's remember, trust is not something that you demand, it's something that is earned. So these numerous nuances to what will generate a level of trust with the practitioners. Ian's mentioned the filing of the plan speedily and on time. That certainly garners some trust. There's a trust of taking everybody in and being inclusive, having good communication skills. We've had the guys from the SAA union on the line. I think the important thing there is to communicate with everybody, to make sure that everybody knows what you're doing. And you can't, as Prof said, you can't get everybody to agree. That's impossible because you've got conflicting goals of the affected parties. The goals of the creditor are very different from the goals of the employee. And if the shareholder is affected by the plan, also very much different views. And then bring in management and our directors. So you've got these opposing forces. You've got even possibly opposing unions where you might have different views on what needs to happen. But I think the important thing there is communication, and importantly, if you are shown to be fair. The Prof touched on something. If there's that wonderful acronym of WIFM written across the practitioner's head, and that's what's in it for me, then they're not the practitioner for the job. If the practitioner is constantly thinking, and as the Prof said, and we've both Ian and I have experienced this, where we've been advising affected parties on the other side of a rescue, where things have dragged on for an inordinate amount of time. And isn't it wonderful to be able to draw fees out of a business that you're keeping in rescue for about 3 years? That's not what it's about. This is all about getting this thing done as fast as possible. And then importantly, not losing focus of what you're there to achieve. The profession is a mixed bunch of people, as the Prof touched on. We've got lawyers, we've got accountants, we've got ex or current insolvency practitioners, all of whom are regulated by their own associations. The question on self-regulation, I think, is impossible to get to work properly. You've got to have a professional body. There has to ultimately be a professional body of turnaround and business rescue practitioners. Not knocking, I'm a chartered accountant, but I don't go into a business rescue purely focusing on the financials. Lawyers, and I've experienced this, lawyers and accountants often get hung up on the legal side of it rather than what is the business? What is the reason for this distress, and how do we solve this problem? Practitioners not being prepared to put a company into liquidation when really they should have, and just hanging on to the rescue for years. We've just had a recent case earlier this month where the courts have ruled that the practitioner has to pay the costs of the other side, on the opposing side, because he's hung on to a rescue for a couple of 3-4 years, and it's going nowhere. Now there was owner disputes, and there was different shareholder bodies disputing it. I realize it was a very complicated matter, but it probably should have been liquidated in the early days. Not close enough to know that categorically, but that was my view on reading some of the papers. So those types of things of doing the job, not losing focus. And there was an article in the press recently about one of the big rescues where the practitioner claimed that they weren't responsible for appointing new management. Well, I'm sorry. Because what you're obligated to do, and we're not talking about a wind down in rescue here, we're talking about handing back a solvent, underlying solvent. What does that mean? It means the balance sheet, the assets exceed the liabilities, fairly valued, and the business has cash flow that enables it to pay its obligations as and when they fall due in the next 12 months. Remember, in rescue, that becomes shortened down to 6 months, but under the Chapter 4 of the Companies Act, it's under 12 months. And if you can't hand back a business that is sustainable over the next 12 months, because you're not able to appoint the management into the business, then how the hell do you hand it back? The shareholders may, especially if it's a listed company, let's just remember, or an SOE. You can't hand that to government and say this is solely your responsibility to fill these vacancies. I believe you really have to hand back a healthy, might not be as robust as it was in its heyday, but it certainly has a chance of continuing to trade and not being challenged in the next 12 months as to its financial viability. So to me, it's a big package. It's not one sorting out one problem. As Ian rightly said, we've had situations where practitioners claimed a contingency fee because he got the business rescue plan approved by the affected parties. What a load of nonsense. You get a contingency fee when you've achieved a goal and the creditors have done better than they thought they were going to do. And if you've exceeded their expectations, then I see no problem in taking a percentage of that for the practitioner because it's a job well done. But don't try and attach easily achieved milestones as to the trigger for the contingency fee, the Act does say it's a contingency based on milestones agreed with the affected parties. I think we've also got to remember that as Prof, and he had in his one slide, very often we go into our first meeting of creditors and people are they're like rabbits in the headlights. They haven't a clue. All they know is they're likely to lose money. They assume this thing really is going to go into liquidation because that's what they've read in the press. Business rescue really is just a delayed liquidation process. So they're terrified possibly of losing their own businesses, certainly in the small to medium market. And so to educate the affected parties at that meeting and try and explain to them what the whole purpose of this exercise is, very often that's missed. It is a requirement of the Companies Act to explain the process of business rescue. I think that is very often missing. And so now you've got people who are uneducated in the law as regards Chapter 6. They know nothing about how to turn a business around. They providing, could be small, could be even large, companies to providing services to the company that's in distress. And all they know is that they're going to lose their money. And if you can get them on board by imparting some of the knowledge of what the Act actually calls for, being absolutely clear on what you're going to try and do. And remember, the practitioner is obligated to state in those first meetings that he or she firmly believes that this company can be rescued. And that comes back to the Prof's earlier slide on the pre-rescue or shortly after rescue, and it's under tight time constraints. And I liked Prof, I liked your terminology on what I always call the subjective feel. I was in mainline banking for a few years, and credit, for example, credit analysis is very much a subjective as well as a scientific approach. And a good practitioner is somebody that's got that stomach, that intuition that says this company can be solved. This problem can be solved and the company can be rescued, very often based on the quality of management. But, and Ian and I will give some examples in a minute when I hand back to him, he'll give his example. But where you have management that are less than honest, and, how do you deal with that and how do you resolve that? It comes back to that issue that the one questionnaire had on, should practitioners be easily removed? And believe me, if we were to do that, any management that was less than honest would be changing practitioners every 30 seconds through the courts, hoping to get a practitioner who is unethical, and there are some of those out there, who is unethical and prepared to bend the rules to suit them. So yeah, guys, just to, the take home for me is the ethics critical, the transparency, the good communications, fairness, and through that, building up that trust. The competencies, I like the Prof's analogy of, you don't know what you don't know, and eventually it's what you don't know. Now, to me, a master practitioner is somebody that is absolutely clear what he doesn't know. I will never have the knowledge of an aviation expert. I would never have a knowledge of a maritime expert, but I would be prepared to do an aviation industry because I certainly can get hold of people who know issues in that particular industry, as well as existing management. If they're playing by the book and are ethical, then using management to get that expertise on the particular matter. I think that's it for now, Ian. Over to you on some examples.
Thanks very much, Peter. And there's obviously there's some SAA affected persons on this, on this call, and they were asking a lot of questions earlier. The Act talks about returning a company to a solvent going concern, but not necessarily a sustainable going concern. And reading some recent articles about SAA, it's, you know, I can understand, and I don't blame the business rescue practitioners for anything necessarily in that matter, but I can understand them wanting to wash their hands of it now and get out as fast as possible. You know, one of the comments was that the business rescue practitioners stated that it was never not their responsibility to appoint executive management. In a normal business rescue scenario, that would most certainly be part of the business rescue practitioner's responsibility. But the BRPs, having cut the debt and having reduced the staff cost and the payroll expense, can now conclude the business rescue and hand back a solvent, inverted commas, going concern to to management, whoever that may be, whoever it may be that the Department of Public Enterprises eventually appoints. But, you know, so their argument would be that it's a solvent going concern. It is solvent with the debt having been written off, but the definition of going concern could most certainly be debated. Let's move on to some practical examples. I'll talk about a practical example that we were recently involved in. Peter can talk about some practical examples as well that we've been involved in or that he was involved in the past. In July, middle of July 2020, so last year, we got appointed to a matter called Consolidated Steel Industries. We were brought in by Deloitte Restructuring, who had been advising the company up to that stage. Company had creditors in excess of R1 billion. CGIC was and is the major creditor, and the company had been involved in a turnaround strategy by management from the beginning of 2020, but COVID-19 unfortunately had a very negative effect on that company. So business rescue was considered necessary, as it was felt, one of the reasons was that it was felt that the shareholder exerted too much influence in order for a sale process to be concluded effectively. So hence it was placed in business rescue under our control. Having placed it in business rescue on the 14th of July, and being myself and my colleague Selo Mkondo were appointed as the business rescue practitioner on the same date. We reduced the costs, or the running costs of the company by 43% in just 2.5 weeks after the commencement of business rescue. Obviously, a lot of that, there was already a Section 189 process in place. And we introduced a process of short time in order to reduce the staff cost with immediate effect. Unfortunately, as Professor Marius explained, retrenchments are inevitably a very necessary part of any business rescue. Remember, our duty as business rescue professionals and practitioners is to stabilize the company as quickly as possible. And often, especially in a COVID environment, stabilize that company means to cut it down to size, and to cut the cost base down to what the revenue of the company is at the time, and sadly that involves retrenchments. The quicker we can cut it down to size, make the company profitable on a smaller basis, and start growing that business again, and keeping it profitable and growing profitability, the sooner we can start to employ people again. In meaningful jobs. So by the time the business rescue plan was published, which was within the 25 days, the plan was actually implemented to a large extent already, in collaboration with the key creditors. So we wouldn't do anything, anything major without having consulted with the key creditors on any major decisions that we were making. The vote was held 6 weeks and 3 days after the company went into business rescue, and the business rescue plan was approved by 98% of creditors in the voting meeting, and therefore adopted. So there were two key divisions. So the core of the business rescue was that we would perform an operational or organic turnaround, fixing the operations of the company and making the company profitable, and combine that with, that would run parallel with the process of selling the two major divisions of the company, which was managed by Deloitte's corporate finance. One of the company's two divisions, a division called Stelcor, which was a aluminium and stainless steel trading division, was effectively closed, and the assets of the business sold just 2 months after the business rescue plan was approved. I talk about speed of execution and getting things done quickly, and this is a prime example of how important that was at the time. Unbeknown to us at the time, ArcelorMittal would sadly let down the steel market quite horribly between October 2020 and January 2021, by not being able to supply the market with steel. But fortunately, we had the proceeds from the sale of the Stelcor division in order to fund the losses in the other division, which was Global Roofing Solutions, for those 4 months. We concluded a sale of the GRS division in January, and we've given the private equity firm that is purchasing the division exclusivity to finalize the deal, to do the due diligence, and to complete the deal by the middle of April, and that is looking to be on track. From an operational perspective, the company, or the GRS, the remaining division, turned a profit in February, and it's more than likely that it'll turn a profit in March as well. The operational turnaround, or the organic turnaround, therefore having been mostly completed at the stage that we are at now. Peter, over to you, if you want to take us through a practical example.
Ian, thanks. I had a case, and this is one of those cases which we went against our normal trend. It certainly took me nearly 2 years to get a business plan agreed. I was appointed as practitioner of a listed financial services company. There had been malfeasance with a number of Sharia-based Muslim investors who had put quite a chunk of money into this company on the promise of a better than prevailing interest rate returns, in fact, significantly higher returns. The company was unable to pay the returns because obviously it wasn't generating the profit from the investments that it had claimed it had made. Some of those investments were made to family friends. Some of those investments were personal assets of the owner. And some of them were valid investments, but long-term investments. That classic problem of using short-term cash, i.e. investors' money with a monthly return required, and investing in longer term, in this case, property-type transactions. The rescue became fraught. The CEO, or the chairman of the company, committed suicide 3 months after I was appointed. The more I dug, the more I found that this was a quagmire, and that there were various problems that had to be solved. And this came to the two of the other things that I think are, I did mention focus. You've got to focus as a practitioner on what you're trying to achieve. And in this case, I was working closely with what was then the FSB, now the FSCA, with the investigations department and the deputy commissioner, to try and get these investors' money back. There were some other creditors, not only the investors, but the investors formed more than 60% of the creditors. And by focusing on that end goal, and dare I say in this instance being dogged, the number of meetings I went into with the investors and other creditors, and was told that really this company should go into liquidation. I'd had an external liquidation calculation done for me, valuation rather done for me, and the valuation came out that the secured creditors would get something in the order of 22 cents in the rand, and the unsecureds would get 4 cents in the rand. As it turned out, through doggedness and, dare I say, some financial engineering, I managed to give the Muslim investors a 3-year secured over property, mortgage security debenture over the development. I managed to get people to come in and develop the property, and the first payments were made to the debenture holders in December just past. It took 4 years to get there, with various challenges. I had a religious Muslim man garnering support from a number of the investors to try and oppose the rescue and try and take over the property asset himself through a company that he owned. It was all very unethical. But in this situation, it was critically important to keep the communication going, not always easy, to keep it going with some people ranging from pensioners who were dependent on this investment to advocates and, surgeons who were invested in this particular scheme. It was a desperate situation. I think certainly, and I'm not polishing my own marble, but the FSB or FSCA certainly gave me feedback that they were amazed that we got this far, that the investors have been repaid. So that doggedness of just sticking to the goal, sticking to the rules, sticking to the fees, these fees became virtually minimal over a number of years, a number of months rather, because very little was being done as I was waiting for the developers to get the property to a position where we could start selling off. Stanzas of significant developments, 500 hectares of land in a mining area of South Africa, residential and light commercial. And things are going ahead, and these are offices and factories and shops and houses being built as we speak, which was very satisfying. But I can tell you now, there were times when I was very tempted to either resign and just say I cannot continue with this, or to just give up and put it into liquidation. And through that doggedness and possibly thick-skinned attitude, I realized that there was an opportunity there, and we just stuck with it, and it has come to fruition. So yeah, but and I sympathize on both sides. I think both Ian and I do. We sympathize heavily with the affected parties. We try and give them as much information as they require to see that they are comfortable with the way we're going ahead with the rescue. But at the same time, I sympathize with those practitioners that land up in untenable situations, and Ian's mentioned SAA, so did Prof, and I think that was an untenable situation. The same firm of practitioners turned the EdCon rescue round in record time, and whilst people had to write off a significant amount of money, it was completed, and the old Edgar's broken up and sold off to various parties. Both those examples, dare I say, for very different reasons, were distressed before COVID came along, because a lot of people now see it, the flavor of the month is to blame the pandemic on the fact that we're in distress, whereas a lot of companies were in distress before COVID, and certainly SAA is one of those. Edgar's was affected by COVID because they did have a turnaround plan in place which had been accepted, and of course that failed when Edgar's were forced to close their stores overnight. So the other thing that I think we're seeing now is, I'm hearing comments about, I had somebody, a lawyer, contact me recently, asked me if I'd meet with one of his clients who was thinking about rescue. She had 2 small beauty parlors in Pretoria. She couldn't afford the rent. How much did I charge for the first meeting? And I was a bit taken aback, and I said, well, nothing. I'll, give her some advice and see if we can do something for her. And he said, oh, well, that's good, because I've just spoken to another practitioner who said he wanted 12,000 Rand to come to the first meeting. Now, that's horrendous. I mean, I do feel very sad that people will do that sort of thing. We're not a charity. We're in it to make money and to survive out of this process ourselves and apply our knowledge to get that income. But, we don't look at a small business and say, either we can't do it because it's too small. What we will do, and we've talked with questions prior to me on the structure of fees, we will normally come up with some sort of monthly contingency, which is affordable. And then if we get success, this is classic in the restaurant, hospitality, tourism type industry, if we have success for it, we will take a contingency which will be agreed with all the parties beforehand, absolutely transparent. So yeah, that's just my example. Ian, back to you.
Thanks, Peter. You're talking about remuneration, and affordability. These things have been mentioned, already. Stephen's question was very pertinent. We believe that every rescue, the remuneration that the practitioner takes should be based first and foremost on affordability. So any practitioner that's taking on small to medium-sized businesses needs to be charging affordable fees. We believe the way to do that is to negotiate a fixed monthly fee with that company, which is affordable, which is agreed with creditors that's affordable, which is agreed with management that's affordable. Charge that during the course of the business rescue, whether it be a year or 2 years or whatever the case may be. Not necessarily collect all of it if in the months that the company cannot afford it. You know, in December, January, we often give our clients leeway in terms of paying, and we don't want to make the running of their business, their distressed business, more difficult than it already is. So everything has to be based on affordability. Even when you talked about accounting firms and so on bringing in more expensive resources than the business rescue practitioner is allowed to charge in terms of the Companies Act. It's a very sensitive subject, and there's various schools of thought on it, obviously. I think the general school of thought is that business rescue practitioners need to be able to earn more than the statutory rates that are prescribed by the Companies Act. Those amounts have been updated, having been, as Marius said, introduced in 2008 as part of the new Companies Act. I think the general school of thought is that in order to attract the necessary skills that business rescue practitioners require, in order to be able to attract high caliber individuals with very strong business acumen into the business rescue space, you need to be able to pay them more. Our thinking is that, obviously the Section 143 meeting is there in the Companies Act, which requires the creditors to approve any fees higher than the statutory hourly rate and any additional contingency fees. And fees need to be stated by the business rescue practitioners upfront, right at the start of the business rescue. It needs to be stated by them to the management and the creditors which specialists they intend to bring in, and including if those specialists are the members of their firm. They need to state the extent to which those specialists will be brought in. In other words, creditors and shareholders and management need to understand exactly what the cost is likely to be right from the outset. Right from the outset, you can achieve an in-principle agreement with the creditors and management, which can then be formalized at the Section 143 meeting, which is normally held at the same time as the meeting to vote on the business rescue plan. But in general, we don't have a problem with the principle of bringing in additional specialists and additional accountants and so on, whatever the case may be, as long as it is disclosed right from the outset and as long as it has the buy-in of creditors and management right from the beginning of the process. Nothing further from my side at this stage, Likani. I don't know if you want to open the floor to questions, perhaps.
Well, thank you, gentlemen, for this very, very well articulated presentation, and also sharing some of your practical experiences in terms of how you've managed to navigate in this profession and be able to achieve some good results. And what I will do now, we've got about plus minus 15 minutes where I'll open the floor for questions, comments, and then maybe we can have some discussions around that. We'll follow the same principle and maybe take three questions at a time, and then I'll give an opportunity to the presenters to be able to respond, and then we will follow that order. So,
thanks. Thanks for. I've seen there's a couple of questions up already. One is from Lucinda. She says that she firmly believes that BRPs should have industry knowledge for the rescues that they're appointed to, or at least have access to such knowledge that is not going to cost the company, which is already in distress, an arm and a leg. We firmly believe that as well. We absolutely. I mean, it's a statement, it's not a question, but yes, that's absolutely how we like to work. You don't want to go into an industry, into a business rescue where you have no knowledge of the industry. That would be it would be nonsensical. Once again, it comes down to having those skills and expert knowledge at your fingertips. If you don't possess the industry knowledge yourself. One school of thought in which we do partially subscribe to is that the business rescue practitioner provides the core turnaround skills, and provided he's got a network, a trusted network of expertise from which he can draw specialist skills, then that's fine. And those trusted networks are so important. So the bigger your business rescue or your turnaround team, or the team that you work with, the wider your trusted network will be. And when I say the word trusted is so important, because if you bring in a specialist to assist you on a specific matter in a specific industry, you want to make sure that that specialist does not have any vested interests other than assisting you to turn the company around. Hence the word trusted. There's another question. Sorry, Peter.
See, there's a question from Asif Bismillah. Asif says, what would you do if not all creditors are responding or attending meetings or validating claims against the company? E.g., 55% of creditors have validated claims against the company and only 15 out of approximately 80 creditors attend the meetings. Mr. Bismillah, what I must remind everybody in terms of the Act, the creditors, the affected people that attend the meeting, the meetings that vote, that's the 143 and the 151, you require a majority of those attending in person or by proxy. So if creditors are not attending meetings, and that might be your major creditors, in fact, who have lost interest in it or just not, and as long as you are absolutely certain that they're aware of the rescue, certainly in larger rescues, it's sometimes quite a challenge informing everybody of the rescue. But if all the creditors have, or all the affected parties have been informed, if they fail to turn up at meetings or fail to vote, that's their lookout. The Companies Act is very specific on this. No creditor who failed to vote cannot claim that they weren't part of the voting process, therefore they don't support the plan. So you do have that protection, but it's a very real problem, especially if you've got, like in my case where I had 200 plus investors in the scheme, trying to get them all into a meeting and all to vote was almost impossible, but certainly I got the majority to vote.
But it's quite seldom that you have major creditors like banks not turning up to vote.
But quite often SARS, SARS, Ian, we know SARS has improved the story and they are now attending meetings, but in the early days of rescues, SARS were very often the largest creditor, because unfortunately when companies are in distress, certainly in the SMME space, the first person you don't pay is SARS, so VAT is in arrears, PAYE is in arrears, and then they wouldn't turn up at meetings. We had battled to get responses from them, but they do now have a team that are responding a lot quicker, so that has certainly improved. Banks in the early days were terrified of rescue, and now the banks have got their specific business rescue units. I think for everybody it's also important to note that the banks have all, I think bar maybe one, have told us off the record that they have a internal register of practitioners that they support, because the banks have got knowledge now of who the practitioners are that are not doing an ethical job or are not doing an efficient job, and making sure that if any of their customers are going into rescue, that they don't fall foul of appointing one of those practitioners. So the market's maturing. It is maturing. It's taking some time, but it is maturing.
Thank you for that, Peter. Can I have maybe a second round of questions to our speakers? I'll just quickly chatting in the meeting chat and see if there's I've got 3 questions. I'll start with the SACC union, and then followed in that order. The second question will also be from the SSCA SG, and then our third question will be from Asif. Please go ahead and continue with your question.
How's it, guys? Okay, so my name is Feroz. What I wanted to ask is the involvement of government and the pressure of government in business rescue. Obviously, as you heard earlier on, we're from SAA and we come from a 15-month business rescue plan or implementation. Is there reasoning that a business rescue plan should take 15 months, or is it allowed in terms of the business rescue rules, regulations, the Companies Act, etc., to go for that particular long time? And is there a right that people, if there's monies available, that these practitioners are paid from those monies? At which stage would a business rescue practitioner exit when there's not enough payments for his job?
Peter, would you like to answer that?
Look, it's a very difficult question. I mean, it's intriguing. We have a WhatsApp group, these 5 directors engaged, and we shared a WhatsApp on the day that Business Rescue that SAA went into rescue. And when we heard it was Matchison and Associates, I said, well, please God that Les and his team survive this, because it's a hospital pass. I think Prof mentioned it earlier. SAA, let's not beat around the bush, was insolvent, absolutely and totally insolvent. If I'd been appointed practitioner, or if somebody had approached me to take on that job, I have to say I would have declined it, because what SAA needed was a shareholder liquidation of the business. However, I'm also not naive enough to think that that's easily done when this is not in the commercial space, it's in the public space, it's a SOE, and therefore, you know, you've got a very, very powerful shareholder. Now, in terms of the Act, unless you're affecting the shareholder's rights, the shareholder, even though they're classed as an affected party, they don't have a vote on the plan. So if the shareholder's rights, and that's as shareholder, not as they might lend money to the business as well, and thereby be a creditor, and those rights they still have a vote on. But if you haven't affected the rights of the shareholders per se, then they don't have a vote on the plan. So in this situation, you've got the most powerful shareholder in the country that you could wish for, and that's government. And I cannot even begin to imagine the amount of behind-the-scenes lobbying that went on with the practitioners about what government desired in order to keep this thing going, because, and we also know from what was coming out into the public domain that government weren't unified on what they thought needed to happen to SAA. We had some members of parliament stating that it should continue in whichever way it can, and others saying, you know, that it should really be commercialized or worse still closed down. They were in the minority, obviously. So with that pressure on the practitioners, don't envy them. I feel that they had the time that it took is predominantly because of that. The influence of government, I was going to say interference, and it probably was interference at one level, but the influence that government had on this process, firstly. And then this was not an easy situation when you've been handed an insolvent balance sheet. And we haven't touched on this very critical thing called PCF, or post-commencement finance. If you don't have funding available to you, you know, Ian covered what we do in the small ones, we'll charge an affordable fee. But if you're taking on a large rescue where you're using a plethora of expert skills to assist you in this rescue, you're incurring costs. It would be unfair to expect any practitioner to do that at their own cost until government had made up their mind. But let's remember that the funding that was promised by government did not come in immediately. It took ages to come in. So during that time, I think the practitioners would have been battling, and I don't comment on the fees they drew. I think it's been in the press, but how accurate that is, I know not. But, you know, the person or the people that were doing that rescue had to be paid. So the time, I think, it can take as long as it takes. As I said, in my unfortunate situation of the investment scheme, that took took 3 years to finalize, and it's going to take another 3 years to pay the creditors out, although I've taken it out because it's substantially complete. The creditors are being paid over a period of time. So that in total, by the end, the last payment will have been a 6-year turnaround. You know, because we are only maturing, I often use the example of, and I believe, and I stand under correction, that there are companies in America that are in Chapter 11 that have fallen foul of, I believe, some trust laws. I think it was in the Chrysler Corporation. That company's been in Chapter 11 since the early 1930s. So there's a company that's been trading all those years, and I stand under correction whether it's still in Chapter 11. But, you know, that will happen. Those occasions will happen. In SAA's case, it shouldn't have happened. But as I said, and I repeat myself, SAA should have been liquidated and sold off, the assets sold off to other commercial operators. People don't like to hear that, but that's the reality of the thing. The thing was hopelessly insolvent.
Yeah.
Can I ask you a follow-up question, please, if you don't mind? The receivership, who is it normal or standard to have the individual who ran through the entire process of business rescue then to be given the duties of receivership? Is it part of the norm?
We don't know. I don't think there is any norm here because, as I say, we're a maturing industry. There's the pros and cons. I would be prepared to take on a receivership post the rescue to make sure that the creditors did get paid. For one reason and one reason only, during the rescue, will have built up in-depth knowledge of what the issues are, in-depth knowledge of who can be trusted and who can't, and that's important, certainly in the case that I was talking about earlier. And on that basis, remember, it's not taking on that responsibility. You're proposing that to the creditors and the affected parties, and the affected parties are voting. And if the affected parties believe that this is inappropriate for the practitioner to take on that role, then the affected parties can call for an independent receiver to be appointed. Very happy with that process. And the opposing thing is, you know, the receiver really is just implementing a structure that has already been agreed. There's very little work to be done. And to me, the whole issue of a receiver is, firstly, clearly it's got to be somebody that you trust, or that's somebody that has a track record. And secondly, that there's not charging a heinous fee for doing this, because it is merely the matter of recovering the payments on behalf of the creditors. But now practitioners got the knowledge and has shown that he can recover stuff from assets and or debtors to pay the creditors. He knows who has to be paid. He's got the in-depth knowledge. So in a lot of instances, it might make sense for the practitioner, but there's no hard and fast law on it. And who appoints it? The creditors, the affected parties themselves have to appoint that person. So they don't just take the appointment.
We've got less than 3 minutes to go on this specific webinar, and I see there's just about, how many hands are there? There's just 2 more hands that I think needs to. If you can please maybe pose your questions, Asif and Vianney, quickly, and then maybe the speakers can try to, you know, attempt to answer them in a very, very short space of time before we run out of this our time that's scheduled for this webinar. Thank you.
Good afternoon. It's Asif speaking. You've touched on a very key issue with regards to PCF, where generally in your small businesses, it's become very difficult to actually get access to PCF. We've got an instance of a travel agency which has been placed into rescue. Naturally, the travel industry has been pretty much the hardest hit with the impact of COVID, and they've essentially now been put onto a prepayment basis for current trading. With regards to the rescue process and the timeframes, they naturally, as a travel agency, they don't have any other assets which could be disposed of. I see you made note also of the 6-year period that you made mention of. In this instance, they've got debtors which pretty much cover the creditors that need to be done. But then, in terms of negotiations, what would you advise in terms of a time frame to put on something like this?
Steph, look, I mean, interesting enough, and we haven't mentioned it yet. Ian and I involved a organisation called COBRA. It's an NGO. COBRA stands for COVID Business Rescue Relief. We are one of the founding partners together with Business IQ and Schindler's, the attorneys. And the whole purpose of COBRA was to assist those smaller businesses in helping them through this crisis, not only through business rescue, very much through turnaround, legal litigation, negotiation, and just general business support. We don't earn any fees from it. So from that point of view, it's a pro bono exercise. But if we take on a rescue, we do try and earn something back on what we call a shared value basis. Ian and I both touched on this. We will come up with a fee that the company feels comfortable with, that we will charge on a nominal amount each month. And once the company comes out of rescue, if and when it can then repay what it owes, as well as pay that amount over a period of time. So once again, underlined, affordability is the important word here. What we've done, and it's a unique situation, because you've got to remember that in order to go into rescue, the directors have to answer two fundamental questions. Is it distressed, i.e. can't pay its liabilities as they fall due in the next 6 months? And then most importantly, can they see light at the end of the tunnel? Is this company rescuable, if I can use that word? Well, obviously in the travel agency, when somebody turned the taps off overnight, and you've still got a person that has a knowledge and network, etc., of the industry, who's taken deposits from travelers who has to either perform the service or pay those back, and the travelers are now getting anxious, well, then rescue is a sensible thing to do, almost like putting the company as we do with human beings when they've got the pandemic and the disease, and putting them into a coma state. And during that period, almost doing nothing other than getting the creditors to agree that you obviously get the creditors to agree that you're going to do that, until this poor individual can get back up on their feet and start running their business again, specifically aimed at the tours and travel hospitality industry. Restaurants, not necessarily the case, because they could do takeouts. But when somebody's business has literally been turned off because of the pandemic, then it's important to assist these people. And then we're aware there's no fund, there's no money, there's absolutely no money, there's no assets to sell. The debtors are not going to pay because they haven't received a service. The deposit takers who manage to pay deposits for tours yet to happen are getting very anxious. It's an ideal situation to put it into a rescue situation until we come out of the pandemic and we're able to travel freely again. So there are solutions. There's lots of solutions out there. It's just about being creative on what those solutions are.
Thanks for that. It's very helpful. And look, I think from our side, our perspective was pretty much the same as well. Where it's literally a time issue at this current moment.
Absolutely.
Thanks. Mine is just a quick one. I've heard that the SAA it was a pure liquidation as per the presentation, but I just want to find out, because the Act does provide for the practitioner appointment to do the investigation, and therefore if there are no prospects, then notify the court. And if then the practitioner has failed to do that, how would you then regard the conduct of the practitioner? Because if you are saying at face value it was liquidation, and an opportunity was given to the practitioners to do the investigation, but still the enterprise is in business rescue, what can we say? I do understand the pressure from the politicians, but then the matter is that has to be reported to court, and I believe that our courts are independent.
I'd look very briefly. The practitioners did cut the costs significantly. They had a challenge to the 189 process, but the staff complement has been cut significantly. I'm not aware, Ian, you might be, whether they sold off some of the assets, but I know that the costs were cut, so they were working on that. And remember, PCF was promised. I agree very much with the Prof said earlier. You just don't throw money at a problem and it goes away. You've got to make sure you've got a viable business to start with. I have no doubt that it went through their mind on numerous occasions to approach the courts. But yeah, as I say, the political pressure, thankfully I wasn't in that room, I imagine having cut the costs and got it down to a size where they believed it was becoming viable, because SA was viable. You know, let's not forget Mr. Coleman Andrews came in there and took more than the practitioners have taken and did absolutely nothing for SAA, you know, in my view. So I think it's had a checkered history, but it has been profitable in the past, and it really should be profitable outside of COVID. Obviously, that was a black swan that floated into the room. So I think
that was the basic risk that control.
Sorry, yeah. So I think, you know, the approach taken was probably the only avenue that saw to them at the time.
Yeah, you know, investigations are not typically. Sorry, I'm getting a terrible echo. If everyone can mute. Investigations are not typically in the general domain of the business rescue practitioners. You know, it's more in the domain of the liquidator. That's, you know, that comes down to the question of should SAA not have been liquidated. I assume government would resist liquidation as vehemently as much as they possibly could, amongst other things to avoid investigations. You know, Section 147, 417 inquiries and so forth. As you stated correctly, it is the business rescue practitioner does have the power to conduct an investigation, but the general thinking is that the business rescue practitioner is there to save the business, and that, you know, if he's investigating, you know, directors and ex-directors and whatever the case may be, then it's, you know, he's not on turning the business around, and that the matter would be better handled under liquidation than under business rescue. But I doubt we'll ever see SAA being liquidated. I'm sure it would be opposed at all costs by government, by legal actions, which can drag on for many, many years. That's just my opinion.
Thank you. Let me quickly maybe run to the chats, and I'm not sure if from your side, Ian or Peter, you can check some of the comments there on the comment section, and then after those, if there's any comment that warrants any response from the presenters, then you can attend to it, and then we'll close off immediately after you've attended anything that's on the chat.
Just, you know, talking to, you know, we've been from SACCA. I see quite a lot of comments that have come through. We've been talking to a prominent union. I don't want to talk about it too much at this stage because it's very early stages, but the idea of converting employee debt into equity, I don't think it would be appropriate in SAA necessarily, but it's something to think about. We were approached by the union and asked whether it has ever been done that employee debt, or in a business rescue, money is owed by the company to employees, be it in the form of salaries or pension fund contributions that have not been paid over, etc., could be converted into equity. I consulted with our team and our legal experts, and none of them had seen it done before. But the general consensus was that there's no reason why it shouldn't be done. And the union that we're dealing with is obviously, you know, one of their key mandates is to promote ownership in the economy by workers. So this is something we're quite excited about, and it's something that certainly warrants more discussion. Is the conversion of employee debt into equity. And the fact that we have been involved in a number of business rescues that have been successful and resulted in return of the company to solvent going concern makes it even more appealing to employee bodies. The fact that workers can effectively acquire equity in the company as a result of the debt that was owed to them, and then in a year or two that equity would actually be worth something. by way of the fact that the company is now would then be trading as a solvent going concern. So that's just something for the union members to think about, and we'd certainly like to engage with you further, in that regard, if that's something that you'd like to speak about going forward.
All right, then with that comment, it brings us to the end of our webinar. And on behalf of the Department of Trade, Industry and Competition, would like to thank our speakers, Professor Marius Pretorius and Ian and Mr. Peter Gordon. We'd like to thank you for your time, for taking 2 hours of your time and just come and share your experiences and your expertise, and so that we can get more insight and more knowledge and be able to share that information. And also from the departmental side of things, we are getting more information as we proceed with these webinars, because part of the work that we are doing now, it complements other work that we are doing on the side. So I'd like to take this opportunity and thank you and thank our speakers. But equally important, I would like to thank all our participants who have made this, a very interesting, engagement where they've, come and attended and have given us, some of the very interesting questions that obviously we wouldn't be able to articulate without them. And on that, with that being said, I'd like to officially close this meeting. Thank you, everyone. Wishing you the best day ahead. Thank you.
Thanks very much for the opportunity. Bye-bye.
Thank you. Bye.